This is part 5A, additional rights of buyer in consumer cases. 48A, introductory. 1. This section applies if A. The buyer deals as consumer, and B. The goods do not conform to the contract of sale at the time of delivery. 2. If this section applies, the buyer has the right A. All right. So right here it says 2. If this section applies, the buyer has the right to A. Under and in accordance with section 48B below, to require the seller to repair or replace the goods, or B. Under and in accordance with section 48C below, I. To require the seller to reduce the purchase price of the goods to the buyer by an appropriate amount, or II. To rescind the contract with regard to the goods in question. 3. For the purpose of subsection 1B above, goods which do not conform to the contract of sale at any time within the period of 6 months starting with the date on which the goods were delivered to the buyer must be taken not to have so conformed at that date. 4. Subsection 3 above does not apply if A. It is established that the goods did so conform at that date. B. Its application is incompatible with the nature of the goods or the nature of the lack of conformity. And 48B, repair or replace of goods, or replacement of goods. One, if section 48A above applies, the buyer may require the seller A. to repair the goods, or B. to replace the goods. 2. If the buyer requires the seller to repair or replace the goods, the seller must A. repair or 2. If the buyer requires the seller to repair or replace the goods, the seller must A. repair or, as the case may be, replace the goods within a reasonable time but without causing significant inconvenience to the buyer. B. Bear any necessary costs occurred in doing so. Bear any necessary costs incurred in doing so, including, in particular, the cost of any labor, material, or postage. 3. The buyer must not require the seller to repair or, as the case may be, replace the goods if that remedy is A. impossible, or B. disproportionate in comparison to the other of those remedies, or C. disappropriated. I said that wrong. Disproportionate. So B. disproportionate in comparison to the other of those remedies, or C, disproportionate in comparison to an appropriate reduction in the purchase price under paragraph A, or rescission under paragraph B of section 48C1 below. Gotta make this bigger. All right. 4. One remedy is disproportionate in comparison to their other if the one imposes costs on the seller which in comparison to those imposed on him by the other are unreasonable, taken into account. A, the value which the goods would have if they conform to the contract of sale. I'm going to read that one over. A, the value which the goods would have if they conform to the contract of sale. B, the significance of the lack of conformity. And C, whether the other remedy could be effected without significant inconvenience to the buyer. Number 5, any question as to what is a reasonable time or significant inconvenience is to be determined by reference to A, the nature of the goods, and B, the purpose for which the goods are acquired. For C, reduction of purchase price or rescission of contract. If section 48A above applies, the buyer may A, require the seller to reduce the purchase price of the goods in question to the buyer by an appropriate amount, or B, rescind the contract with regard to those goods if the condition in subsection 2 below is satisfied. 2, the condition is that A, by virtue of section 48B(3) above, the buyer may require neither repair nor replace the goods, or B, the buyer has required the seller to repair or replace the goods, but the seller is in breach of the requirement of section 48B(2)(a) above to do so within a reasonable time and without significant inconvenience to the buyer. 3, for the purpose of this part, if the buyer rescinds the contract, any reimbursement to the buyer may be reduced to take account of the use he has had of the goods since they were delivered to him. And let's see, 48D, relation to other remedies, etc. 1, if the buyer requires the seller to repair or replace the goods, the buyer must not act under subsection 2 until he has given the seller a reasonable time in which to repair or replace, as the case may be, the goods. 2, let me see. All right, so there was 1. 2, the buyer acts under this subsection if A, he rejects the goods or terminates the contract for breach of condition. C, he requires the goods to be replaced or repaired, as the case may be. God dog it. All right, so I'm gonna go to 48E. 48E. Powers of the court. 1. In any proceedings in which the remedy is sought by virtue of this part, the court, in addition to any other power it has, may act under this section. 2. On the application of the buyer, the court may make an order requiring specific performance by the seller of any obligation imposed on him by virtue of section 48B above. 3. Subsection 4 applies if A. The buyer requires the seller to give effect to a remedy under section 48B or 48C above, or has claims to rescind under section 48C, but B. The court decides that another remedy under section 48B or 48C is appropriate. 4. The court may proceed A. As if the buyer had required the seller to give effect to the other remedy, or if the other remedy is rescission under section 48C. B. As if the buyer had claimed to rescind the contract under that section. 5. If the buyer has claimed to rescind the contract, the court may order that any reimbursement to the buyer is reduced to take account of the use he has had of the goods since they were delivered to him. I'm going to read that one again. 5. If the buyer has claimed to rescind the contract, the court may order that any reimbursement to the buyer is reduced to take account of the use he has had of the goods since they were delivered to him. Number 6, the court may make an order under this section unconditionally or on such terms and conditions as to damages, payment of the price or otherwise as it thinks just. 48F, conformity with the contract. For the purposes of this part, goods do not conform to a contract of sale if there is in relation to the goods a breach of an express term of the contract or a term implied by section 13, 14, or 15 above. Let me see. We're going to hurry up and do part 6. Part 6. Actions for breach of the contract. Seller's remedy. 48. Action for price. 1. Where under a contract of sale the property in the goods has passed to the buyer and he wrongfully neglects or refuses to pay for the goods according to the terms of the contract, the seller may maintain an action against him for the price of the goods. Page 22. 2. Where under a contract of sale the price is payable on a day certain, irrespective of delivery, and the buyer wrongfully neglects or refuses to pay such price, the seller may maintain an action for the price although the property in the goods has not passed or the goods have not been appropriated to the contract. 50. And All I'm doing is getting this baby where I can see it. 50. Damages for non-acceptance. Ooh, damages for non-acceptance, where the buyer wrongfully neglects or refuses to accept and pay for the goods. The seller may maintain an action against him for damages for non-acceptance. 2. The measure of damages is the estimated loss directly and naturally resulting in the ordinary course of events from the buyer's breach of contract. 3. Where there is an available market for the goods in question, the measure of damages is prima facie to be ascertained by the difference between the contract price and the market or current price at the time or times when the goods ought to have been accepted, or if no time was fixed or acceptance for acceptance at the time of the refusal to accept. Buyer's remedy. 51. Damages for non-delivery. 1. Where the seller wrongfully neglects or refuses to deliver the good to the buyer may maintain an action against the seller for damages for non-delivery. Uh, 2. The measure of damages is the estimated loss directly or naturally resulting in the ordinary course of events from the seller's breach of contract. 3. Where there is an available market for the goods in question, the measure of damages is prima facie to be ascertained by the difference between the contract price and the market or current price of the goods at the time or times when they ought to have been delivered, or if no time was fixed at the time of the refusal to deliver. 52 is specific performance. Specific performance. 1. In any action for breach of contract to deliver specific or ascertained goods, the court may, if it thinks fit, on the plaintiff's application, by its judgment or decree, direct that the contract shall be performed specifically without giving the defendant the option of retaining the goods on payment of damages. 2. The plaintiff's application may be made at any time before judgment or decree. And then 3. The judgment or decree may be unconditional or on such terms and conditions as to damages, payment of the price, and otherwise as seem just to the court. 53. Remedy for breach of warranty. Damages for breach of warranty. Remedy for breach of warranty. 1. Where there is a breach of warranty by the seller, or where the buyer elects or is compelled to treat any breach of a condition on the part of the seller as a breach of warranty, the buyer is not by reason only of such breach of warranty entitled to reject the goods, but he may A, set up against the seller the breach of warranty in diminution or extension of the price, or B, maintain an action against the seller for damages or the breach of warranty. 2. The measure of damages for breach of warranty is the estimated loss directly or naturally resulting in the ordinary course of event from the breach of warranty. From the breach of warranty. Oh, from the breach of warranty. All right. I don't even know if I did 2. So I'm going to do 2 over. Two, the measure of damage for breach of warranty is the estimated loss directly or naturally resulting in the ordinary course of event from the breach of warranty. 3, in the case of breach of warranty, the quality such loss is prima facie the difference between the value of the goods at the time of delivery to the buyer and the value they would have had if they had fulfilled the warranty. 4. The fact that the buyer has set up a breach of warranty in diminution or extension of the price does not prevent him from maintaining an action for the same breach of warranty if he has suffered further damages, interest, etc. 54. Interest. Nothing in this act affects the right of the buyer or the seller to recover interest or special damages in any case where by the law, interest or special damages may be recoverable, or to recover money paid where the consideration for the payment of it has failed. When we come back, we're going to hit part 7, supplementary.